Parties and alcohol, hey, they've been known to happen. Well, that takes us to this week's case. Real case involves people who are working for the Marriott Hotel in San Diego, California. Now, before we get into the facts of the case, a little bit of the law that you need to be aware of, and that is when somebody is acting on behalf of an employer, when they're driving a FedEx truck or a UPS truck or doing something else, if they rear end somebody, they get involved in an accident. If they're acting on behalf of FedEx or UPS, well, FedEx or UPS is responsible. It's called respondeat superior under the law. Well, when you have parties that are hosted by an employer, it is considered that that's part of your employment because the parties are held to develop goodwill, camaraderie, allow people who work together to get along together. And so when you're attending a company party, you're in course and scope of employment. Now, we get to the question of alcohol. Well, that's the issue that arose at the Marriott party in San Diego. The fellow who is attending the party had been a bartender for the Marriott Hotel in San Diego. Michael Landri was his name. Well, before he got to the company party, he had already had a beer and some whiskey. He took a flask along that was filled with whiskey to the party. Gets to the party, he's there for about 2 hours, and he is having some of the adult beverages that are being served. Now, Marriott said that when they were hosting the party, what they were doing was limiting alcohol by giving everybody 2 drink tickets, and they were only serving beer and wine. Well, what the evidence later showed is that they forgot the 2 drink maximum, and they were giving people abundant amounts of alcohol and serving alcohol from the hotel's supply of hard liquor, to the point whereby one of the guys who was manning the bar that was there for the employees was pouring whiskey into the flask that Michael Landri had brought along. Okay, so Michael, needless to say, had become relatively intoxicated. He left the party and he with some co-workers. They went to his house, and then one of the co-workers needed a ride. So Michael left his house, takes the co-worker home, or is in the process of taking the co-worker home, when he rear-ends another vehicle at a high speed and kills the driver of the other vehicle. The estate of the man who was killed brings claim against Michael, obviously, but also brings claim against the Marriott. And it brings claim against the Marriott, his estate brings claim against the Marriott, contending that Michael was in course and scope. The Marriott argues, wait a second, he was not in course and scope of his employment because he came, sure, he'd had a few drinks, but when he left the hotel and went home and got home, that ended course and scope. It was all over. The party was over for him, literally, and we were no longer responsible. So when he took that co-employee home and got involved in the accident, that was outside course and scope. On the other side of the coin, the people arguing on behalf of the estate for the man who died said, alcohol is dangerous. Bad things happen when people get drunk. In this instance, if you start a chain of events in which you allow people to get drunk, and that person then engages in some conduct later that causes injury or death, well, you're responsible if the alcohol was consumed in the course and scope of employment. So, at the trial, before it ever went to a jury, the court heard a motion for summary judgment and decided in favor of the Marriott, They said, you're right. Michael, when he went home, ended any involvement and he was no longer in course and scope. He wasn't working. And therefore, you guys are not at fault. Well, plaintiff took the case up, went up to the 4th District Court of Appeals in the state of California. And there, that court said, well, this is very interesting. Very interesting. And they came away and they said, what we find is that alcohol is indeed bad news stuff when it's drunk in excess. When you are serving large amounts of alcohol at a company party, you are going to be responsible for any of the bad things that can happen, death or injury, as a result of that employee being drunk, even though they may have gone home and gone someplace else. The only question that the appellate court had was, is it foreseeable? Is it foreseeable that Michael would have gone home and then left his home to take somebody else home, or is that so outside of what's foreseeable as to not make the Marriott responsible. In short, they sent it back down to the trial court to say, you guys have to decide, a jury has to decide, whether or not it was foreseeable that Michael would go home and then take someone else home while he was still in a pretty inebriated state. Okay, so we saw two arguments here, one on behalf of the Marriott that the trial court agreed with, one on behalf of the plaintiff that the appellate court agreed with. The appellate court is controlling. That becomes the law in this case. But the big question is, was Michael taking somebody home foreseeable? And that's a question of fact that's going to be decided by the jury. Okay, we bring you this case as you bring cases every week so you understand how the law works. I'm David Allen.